So hello guys, today we'll be discussing the case of SARLA MUDGAL vs Union of India, in which different questions were answered. For example, if a husband converts to some other religion, then what is the effect of his marriage with the first wife, and what will be the effect of his second marriage after conversion. ये सब नहीं पता, चिंता मत करो, मैं हूँ ना. चलिए स्टार्ट करते हैं. सो गाइज एपरेंटली मैंने वीडियो पूरी रिकॉर्ड कर ली थी, पर माइक नहीं ऑन हुआ था, तो हम फिर से स्टार्ट करते हैं. सब मिटा दो. Yeah, so let's start again. So keeping the last class in mind, please remember the concept of polygamy over here, which means one man can have multiple wives. Now this concept is applicable in Muslims in a limited concept, and in Hinduism it is completely forbidden. Now over here, let's see the example. Suppose there is a husband H who is married to W, and they both got married on 1/1/2000, and their happy marriage continued for about 5 years. In the meantime, H met a beautiful girl Y, and they both decided to get married. But since Hinduism doesn't allow polygamy, so both H and Y converted to Islam. Now what we have to see are these two circles. What will be the effect of this first marriage? Will it become void merely because of conversion? What will be the status of this second marriage? Will the second marriage be void per se? Will it be valid? What, like, the rights of Y will prevail over W, or rights of W will prevail over Y? So what will be the scenario? So the two questions came before the court in the landmark judgment of Sarla Mudgal vs Union of India. So the judgment was delivered by Honorable Justice Kuldeep Singh of Honorable Supreme Court of India on 10/5/1995. It was a 3 judges bench, and the court discussed the following questions: whether the marriage between H and W dissolve automatically, that is per se. What is the status of second marriage? The first marriage was solemnized under the Hindu Marriage Act, that is HMA 1995, and it will be governed by it. In the above act, it nowhere states that marriage will dissolve per se upon conversion of a spouse. Rather, under section 13(1) subclause 1, it gives a right to the wife to claim divorce from the husband. Hence, here, due to the conversion of H, the marriage is not dissolving per se. Either it is giving a right to W under section 13 subclause 1 subclause 1 of Hindu Marriage Act 1995 to claim a divorce from H. So the first question is hence answered. The status of second marriage will be void. It will be void. The second marriage will not be valid. Though though the second marriage was performed after conversion to Islam, which allows limited polygamy, but it would be a violation of section 11, 13, 15, 17 and 5 subclause 1 of the Hindu Marriage Act 1995. Moreover, it will be contravention of constitutional principles of justice and equity to declare that such marriage is valid when the first marriage under Hindu Marriage Act still subsists. So the question comes to our mind, since the second marriage is void and the first marriage still subsists, only giving the right to W to claim a divorce, isn't it looking like the Hindu Marriage Act is prevailing over the Muslim personal law? So that question is also answered by the Honorable Supreme Court, which states it does not mean that Hindu Marriage Act prevails over Muslim marriage. Rather, what it means that the moment first marriage was solemnized, certain civil rights occurred in favor of the wife of first marriage, and these rights of wife of first marriage cannot be done away with automatically due to the conversion of the husband, followed by the second marriage. However, the civil rights of the wife of first marriage will prevail over the civil rights of the wife of second marriage. In case of conflict between two personal laws, neither prevail. It is a very important point. The Supreme Court held that neither of the personal laws prevail over each other. It is only the civil rights of the wife of the first marriage which will prevail over the civil rights of the wife of second marriage which occurred later in time. So next is the case of Lily Thomas versus Union of India, where the Honorable Supreme Court discussed the concept of polygamy in India, and the judgment was delivered by Honorable Justice S. Sagar Ahmed. The court discussed the concept of polygamy in India. In Islam, limited polygamy has been allowed up to 4 wives due to the Battle of Uhud, in order to provide shelter and support to a lot of widows of the soldiers who died in the battle. But a wife can also claim divorce as per Section 2F of Dissolution of Muslim Marriage Act 1939 if a husband is unable to treat all wives equally. Hence, there was a battle in history that is called as the Battle of Uhud, in which many people died, so leaving a lot of widows. So in order to provide shelter, food and support to these widows, limited polygamy was allowed in Islam up to 4 wives. So it was for a noble cause, and later on it was felt the need in the Dissolution of Muslim Marriage Act under Section 2F to include that if a Muslim is marrying 4 wives and he is unable to treat all 4 of the wives equally, then any of the wife can claim a divorce on the ground that she is not being treated equally or at par with the other 4 wives. Now let's see the case of Khurshid Ahmed Khan versus State of UP. In this case, it has been held that Article 25 of Constitution protects religious faith and not a practice. Next is a case of Fahim Ahmed versus Mawiya alias Lakshmi. It is generally not necessary that he should observe any particular religion to be a firm believer in a religion, as no court can ascertain the sincerity of religious belief. Therefore, if a person is converting to Islam and he is not following the concept of polygamy, or he is not going to masjid every day, or if he is not reciting namaz every day, then it does not mean that he does not have a strong belief in Islam. And Article 25 only protects religious faith and not a particular practice that is followed in that religion. So it is to be noted that as per Section 21A of Special Marriage Act, if a Hindu marries a Hindu under Special Marriage Act, then he will be governed by their personal law, which is Special Marriage Act, Hindu Marriage Act, HMGA, Hindu Minority and Guardianship Act, etc. Even if Saptapadi has not been performed. Therefore, if a Hindu marries a Hindu under Special Marriage Act and does not perform Saptapadi, then also they will be governed by their personal law. But if a person of Hindu religion marries a person of other religion, that is any other religion, then they will be governed by Special Marriage Act. Similarly, if a Muslim marries a Muslim under Special Marriage Act, then they will be governed by Special Marriage Act and not Muslim personal law. It is a very important distinction under section 21A. Next, let's see a situation. For example, A and B get married under Hindu Marriage Act and they convert to Islam. Now they will be governed by Hindu Marriage Act or Muslim personal law, considering A and B both are Hindus. So these two questions have been answered by Honorable Privy Council and Honorable Delhi High Court in the following judgments. In the case of Khambata versus Khambata, Privy Council in 1934 held that according to this, they will be governed by Muslim personal law. Like whatever law was prevailing at the time, they held this. But the spirit of the law at that time was also the same. And according to Vilayati Raj versus Sunita, Honorable Delhi High Court in 1983 held that according to this judgment, the law according to which they married will be followed. That is Special Marriage Act. According to law which they married will be followed. So guys, आज के लिए इतना ही. In next case, we'll discuss Davar, Meher or Sadak. These are the different names of the same thing. See you in the next session. Thank you. Bye bye. Sweet dreams.